right, guys, we're about ready to get started back up again. Our next speakers, Ken Bossin and Joe Hada out of Cleveland. They work out of the same office. One has been practicing about 50 years, the other one not quite that long, but they have more similarities than differences. They both have a phenomenal understanding of the law, the statutes, and technology and how to use it. And they're going to talk to us today about whether things are inadmissible or not, and maybe some misconceived notions that we may have on that subject. Take it away, folks. All right, guys, let's listen up.
All right, so we're going to get started here. I'm going to try. Man, is that loud? All right, so the other difficult part here is that as the tech guy, it's hard to monitor this. It's my first time speaking and being a tech guy at the same time. So I'm adjusting the mics as I go. All right, so this presentation was kind of born out of this process we've been going through, things we're looking at in terms of, that was a fun little interesting YouTube video that I put out. How can we actually use that? So we've been talking about this presentation for a while, and we're going to start off by going over some of the things that we'd like to get into trial. And the way we are going to do that is by getting it into the motion to suppress to begin with. There's our favorite case, some of the prosecutor's favorite cases, is State versus Edwards. This was a case that said we can prove ODH compliance, and we can do that through hearsay. Rules of evidence do not apply in a motion to suppress hearing. Well, state like that because they could just throw paperwork out there and say, we comply with the ODH regs on a breath machine. But as soon as rules of evidence don't apply for you, now they don't apply for us. So in this presentation, we're going to go over all the quirky little things that we think help us out. And it came from this book I created. This is the NHTSA manual cover. So then when I created my book, I made this the cover. It looks a lot like it's a manual, but it's not. And so what's the NHTSA logo? We replaced one of the logos with NIST because we're defense attorneys, we care about science. We took out the IACP logo, we replaced it with the DOI DLA badge. It says shiny badges don't grant extra rights. And I put the revision date on there. Fun part is I go slap this down on trial table next to my NHTSA manual, right on top of it. And the cops will walk by, see the revision date. Oh, man, came out with another manual. So it's fun. But in this book, it's full of manuals and studies and some of the stuff that we have in this presentation. And it needs some updating, but quick reference, case guides, all that sort of thing. So let's get into a few of the things that we talk about that we'd like to use in trial.
One of the things that I've changed my mind over the years is I always said, don't file a motion to suppress in every case if you don't have to. Well, if you have any thoughts of getting anything into evidence at trial, you have to file a motion to suppress because that's where you get everything in. If rules of evidence don't apply, reports, documents, letters, anything that you want can be admitted at a motion to suppress as long as you can cross the cop or anybody else who's testifying about those documents. You can cross them at trial.
And we're going to talk about that towards the end too, about how we kind of shoehorn these things in at the trial level. Joe,
yeah.
All right. So the first one we're going to talk about is one of the validation studies. Sean was up here talking about studies. Who else is it? Brock had the studies up here, the San Diego study. we've heard a lot about studies already. Jeff Meadows was just talking about how, yeah, motion to suppress is one thing, but we're getting the testimony that we need for trial. So the first one, I like to lead with this one because everybody's heard it before. It's the bloodshot glassy eye study that says this is not a reliable indicator of OVI or whatever the language is that they say there. As soon as I start the question on this, I start to make a record. The prosecutor objects. There's debate over whether this study is actually mentioned in the manual. And then I have to say to the judge, well, yeah, I mean, here's the reference for it, but State versus Edwards, rules of evidence don't apply. I'm going to bring this in regardless. And we can have this back and forth. But I would like to use this one first because I've heard of it. So I get this one in, and the prosecutor learns that I just fought with Joe over nothing because it's going to come in. And so the next time I say validation study, they're like, it's faster. This is obviously not winning over the judge. Just let Joe go do it. So they don't object, and I just plow ahead, and it actually makes it faster. And the judge lets me run into more of these things. So this is the one I like to use first, but there's a lot of good stuff in the San Diego study, and I was going to run through that one next and why I find value in that, but it looked like you might say something.
No, you're good.
Okay. So this obviously discounts bloodshot glassy eyes or bloodshot eyes and flushed face, I believe. But the San Diego study, Brock was talking about for whether or not field sobriety tests go towards impairment or predictor of a BAC. My take on this is that the walk and turn has little or no evidentiary value based on this study. And I'll show you the progression and how I get there. So I use this study it's the San Diego study. When you take the instructor course, they will teach the officers, this is a study you rely on. When they ask you, you don't go back to 1977, you don't use the other studies, you absolutely don't use the robustness study, but you want to rely on this one because this is the one with all the good data. Well, there's one page that helps us out. And let's see here. There's that page 21. All right, so this one, they have what used to be in the NHTSA manual, used to have an arrest matrix. They removed that and replaced it with some picture of a guy getting cuffed up. I don't think it was because of this study, but it very well. This cuts so well in our favor that it could have been. In this one, they talk about people who have 2 or more clues and people who are either above or below the legal limit. I'm going to focus on the walk and turn for this one. The stats are not great on the 1 leg stand, but it's best for the walk and turn. So if we look at the walk and turn specifically, we've got people, you can see there, less than 2 clues, more than 2 clues, over and under the legal limit. But most importantly, all the people under the legal limit, that bottom row of the matrix. People who have less than 2 clues, that was 36 people. People who had more than 2 clues was 40. Well, 40 is bigger than 36. So most of the people under the legal limit failed the walk and turn. So the argument is that test is difficult to do sober. And I know when I say sober, it's blending that predictor of BAC versus impairment, but if I'm saying impairment, they're going to agree with me. So this test looks like even people who are sober have a difficult time performing that well. Most of the people under the limit fail it. Well, if you go back to the NHTSA manual, it tells you that tests that are difficult for a sober subject to perform have little or no evidentiary value. And that's where I get to the conclusion that the walk and turn has little or no evidentiary value. Now, the value in that is, yes, it takes some time to go through all those numbers, but you're gearing up for the testimony that you want to have at trial. So when you come to trial and you've already been through all these numbers, now you can hit it real quick. You don't have to bore the jury with math. Even though it's not difficult math, you don't have to go through all that. You can just start in on the officer with the conclusion because he's already been there. Another one is the robustness study. The robustness study was from 2007. They had the 2006 manual, and the 2009 version of 2006, and then we progressed to now to 18. So this study came out prior to the recent changes in the manual. And what they tried to show with this one was that you can mess up the HGM just a little bit and everything's still fine. Well, it didn't work out that way. So in the 2018 manual, they don't make any mention of this study. They pretend it does not exist because it did not work out the way they wanted it to, and it gives a lot of ammunition to us. So that's why we want to get it in. I'm going to run through that for you, the ways we can use it, and try and keep an eye on the clock. When did we start?
A little while ago.
A little while ago, huh?
You don't have to submit this stuff before the motion hearing. And you don't have to submit all of it.
There, now you're on camera.
If you, oh, that's good. You can take pieces parts and you're offering it into evidence and it can be labeled and you can ask the officer about it. Give him a copy, let him take it home. But don't give him the whole study. Just give him what you cross-examined him on. He's going to keep looking at that and he's going to keep thinking about the answers he gave. He's not going to be happy. So you can get all this stuff in. You don't have to worry about validating it. Although validating is a good word because police don't like that. But that's the way you want to prepare. Some of the courts in Ohio say you don't get any fields in until they prove that they were done correctly. Now, I don't know whether all the courts are doing that, but they insist that the prosecutor present the manual. We've got some case law up in the Cleveland area that says you don't present the manual, you haven't shown it was done, they're out. Well, the question is, do you want them out? And we're going to talk about that a little bit later, but there are times when you're going to want those fields in because it gives you an opportunity to show the jury how poorly they were administered.
Or unfairly. So I know I just skipped on to the robustness study, but the my favorite story of doing this with the walk and turn was in Oberlin. And the judge let me go through the whole bit. I get to the end and the officer says, isn't it true that it has little or no evidentiary value? Judge stops the hearing, throws his hands up, and why do we even do these tests? I said, I don't know, Judge. And I ended up losing the hearing anyway. But we got it in, and that's on the record, and they know that it's going to come back to bite them when we actually get going to trial. So if you going back to the robustness study in the HGM, if you want to know what 4 clues or 6 clues means, you might look in the NHTSA manual, and it's going to tell you that having 4 clues indicates a BAC over a 0.08. Now that's the 18 manual. If you go back to the 2009 version of the 2006 manual, it says that 4 clues means that the person's BAC is over a 0.10. They adjusted it. They didn't do any new studies. They just reworked the numbers. Some of that I can almost get behind, but when we get into the robustness study, you see how absolutely ridiculous this is. So in the robustness study, I said it again. I said this was in 2007. I think it's page 19. I could be wrong, but this is one of my favorite pages in the manual, and it explains what those clues mean and when you can see those clues. So if you, I think it's 19. You have to look that one up, but it's in the materials. When can you see the appropriate amount of clues? Well, if you look to the number of signs, you can see 4 clues down to a 0.03. And that's perfectly acceptable. So the NHTSA manual tells you that 4 clues means that you're over the legal limit, but when they do their own studies, they admit that you can see 4 clues down as low as a 0.03. You can see 6 clues down as low as a 0.06. So is that if somebody has 4 or 6 clues on the HGM, is that in any way indicative of probable cause? If it proves only, or it can't show that they're exceeding the legal limit. No, it can't be probable cause if the person is operating a vehicle under the legal limit. So this is something that we would like to use, obviously a trial, but, and I said, this isn't going to be successful. I'm not going to get this test suppressed, but I'm going to start to punch holes in it and get that testimony ready for trial through this little process. But the robustness study goes on in another way. That's a little bit more fun. You're going to say something now? No. Okay. All right. So the other thing about the robustness study is the level of false positives. If you go in, they actually show you people at different BACs, how many clues they had at that BAC level. So I think they did somewhere in the 20s, 25, 26 people. They tested them from very low BACs up over the legal limit. But the whole point of the HGN and having these clues is to distinguish between somebody who is over the legal limit and who's under the legal limit. So if you're finding people who are under the legal limit but have 4 or more clues, then according to the NHTSA manual, 4 clues meaning that they're supposed to be over the limit, then those are false positives. So if we look at the numbers, I'll go through some of these for you. We are working on the air conditioning, I swear. We've called on this. But the robustness study, they did the study in a few ways. They did it right. Then for, say, height, they did it too high and then too low. So doing it correctly was 2 inches above eye level. Doing it incorrectly was directly at eye level. And doing it too high was 4 inches above eye level. Now, we've all seen officers who have gone way outside the bounds of this, and the judge still says, yeah, that's okay, let it in. But if we go over the numbers, we can show the false positives and how they increase when you do deviate from the process. As Tony Palacio says, this robustness study was a great opportunity for NHTSA to just say, hey, we did the studies, when you mess it up, and it screws with the numbers. But what they should have said, rather than adjusting the number of clues, is the study proves that you just have to do it right. You have to do it correctly. But I disagree a little bit, because when you do it correctly, you have a high false positive rate. When you do it correctly, right at 2 inches above eye level, 54% false positive rate. You can look down the numbers, all the people who are under the legal limit, how many clues do they have? If they've got 4 or 6, that's a false positive. So more than half of the people under the legal limit are getting arrested when they shouldn't. If they hold the stimulus too low, that number jumps. It jumps to 79. And if they hold it too high, it jumps again to 83. So you're having an incredible amount of false positives on the HGN.
If you can get the officer to look at this and get him to agree, or not even agree, if you can get him to say it, that you've got figures, and you get him testifying for you. And that's all you need is a transcript.
Yeah. And I mean, this is at the hearing, at the motion hearing, I can make the officer go right down the list and say, all right, well, the person who tested a .068, how many clues did he have? And we can count all these up. But if we do it at the motion hearing, by the time we get to a trial, you can just give the conclusions that I have on the slide. You can just jump straight to the end of the story because you've already been through it all.
And you don't have to worry about boring the jury, hearing stuff that they wouldn't understand anyway. You're going to let the officer explain to the jury what your point is.
So if we go to the other side of the robustness study, this is the one where they're holding it either too far or too close. Again, they did it correctly. They did it correctly first and got 2/3. 2/3 of the time there's a false positive rate. And that's people who are under the legal limit. The test is performed correctly and we're arresting them. If you hold the stimulus too far, you're getting 85%. And if you hold the stimulus too close, that false positive rate jumps all the way up close to 90%. So these are, and I know Cleve, is Cleve here? No. Cleve does a great presentation about measuring whether HGN is too close by measuring his client from the nose to the back of the head and then comparing that gap. But too close, you're getting a near 90% false positive rate. So it's you can approach it a number of ways at trial as far as it being unfair, but they're forcing errors that are forcing them to arrest people who are under a legal limit, not committing a crime. There's one other one I wanted to pitch in. We did too high, too low, too far, too close. There is one other one as far as too fast. If you move the stimulus too fast, there's a study, nystagmus testing in intoxicated individuals. They tried to study putting these people in different positions. And there's some good stuff in the study, but the only reason I'm bringing it in here is they establish what it is to go too fast. And if you go too fast, it'll cause a condition called catch-up saccades, where the eyes are jumping to catch up to the stimulus. And I've done it, I've seen it, caused it. It looks just like lack of smooth pursuit. Tim. Question is, what do they say is too fast? Greater than 30 degrees per second. That's roughly your 2-second pace on lack of smooth pursuit. So when you, I just advanced this slide. When you exceed that pace, now you're causing catch-up saccades. It looks just like lack of smooth pursuit. So I just want to throw that one in there. But those are a couple of the studies. I want to get into some of the other cool things that I have in that book. And we're going to have to keep an eye on the time. But one of my favorites is body weights. So now we use body fat percentage, BMI, things like that to measure whether or not somebody is very healthy. The original study where they came up with these field sobriety tests, that was 1977. So what did 50 pounds overweight mean in 1977? Well, not a bad indicator is a study by a life insurance company from 1979. Now this is published, easily found on the internet. It's one of my favorite. I've tried to find a number of these. Sometimes this is divided between men and women. If you look on the internet, you can find ones where they combine the two, and then you get these nice ranges of what's average, what your average weight's supposed to be. So the reason I like this one is nearly anybody can be 50 pounds overweight.
You just have to work at it.
So if you go, let's call me 5'10" today. Football coaches said more at times, but that would make my weight a medium frame 151 to 163. So I'm in the mid 50s. Well, last week I was about 209, 210 on the scale. 50 pounds overweight. So if you can use these, maybe your client needs to stuff a sweatshirt underneath their dress shirt, but nearly anybody can be 50 pounds overweight. And one of the best ways to do it is just with their driver's license, especially if it hasn't been updated. Just check and see what their weight is. Because I'm sure nobody wants to be getting on a scale in a courtroom.
But it's always going to be lower.
Yeah, right. Let's see here. All right, so that's a fun one. That one's in the materials. Another one is everybody in Ohio has tried to squeeze this in one way or another. But Mark Gardner asked me one day, how do you get this in? Nobody who was associated with this works there anymore. They're gone. They could be dead. I don't know where, but you're not going to get them to testify. So if we can get into the motion to suppress hearing, say, aren't you aware that there's a memo that says, because they're now they're aware. So this establishes the 20 minutes. I know that whatever the case law is, I don't care. It's not about whether or not the judge is going to kick the breath test. It's getting this on the record. So when we go to a jury, they know that the officer screwed up. He should have waited 20 more minutes because there's mouth alcohol, and that will mess up the client's test. So getting it in at the motion to suppress is important, but there's, this is, how do you qualify this? Public record. This is a business record, maybe of the ODH. So we try and we'll talk more about stacking our causes for getting it in. But the next one is the BD Vacutainer tube guide. Here in Ohio, you have to have a solid anticoagulant in the tube per the regs. That is the anticoagulant that fights clots and microclots. if it's not mixed well, because when we look at this for our gray tops, it's got to be inverted 8 times. If you're not inverting it properly, if you're not mixing it properly, you can have the formation of microclots, and that can affect your test. But the other part of this tube guide and why it's important is often the officers don't know what's in it. They don't read the tube. They just say, oh, it's a gray top. We use gray tops for that test. There's a white powder in the bottom. Well, okay, but there's 3 different kinds of gray tops. 2 of them have an anticoagulant. And is Ross right here? It's going to back me up on this. When I did my phlebotomy course, there's potassium oxalate. That is the solid anticoagulant we typically have. The other one is EDTA. If I remember correctly, the EDTA tubes have like a mist in there. It's a liquid anticoagulant. So that one's not the one you need. The sodium fluoride. Sodium fluoride is the anti-glycotic, the preservative. But if you look, there's a gray top that has potassium oxalate and sodium fluoride. There's a gray top that has sodium fluoride and EDTA. And there's one that just has sodium fluoride. So if the officer doesn't know, he could be sitting there with a gray top tube that just has sodium fluoride in it and no anticoagulant. But what's our reference for this? This tube guide's great, but there's more we can get in at the motion suppress. Ken gave me this book. It was the Phlebotomy Essentials, the textbook for phlebotomy.
That's because I didn't understand it. And I needed somebody to read it.
I read it twice before I ever went to class for phlebotomy. But it's got some good pieces of information in there that if we get this in there, whether it is with the phlebotomist, with the lab people, with the cop, whatever we can do to get this in there, this is something that we can use at trial. So this is a little treatise for cross-examination. But let's just to show you a couple of things that it has in it. This sentence right here: inadequate mixing of an anticoagulant tube leads to microclot formation, which, the important part, which can cause erroneous test results. Right there, if you can't trust the test result because they didn't mix it right, that's pretty devastating for that number at trial. And when I walk the phlebotomist through what they did that day, I get very specific about what they did with the tubes. And it's fun to finish that out, have them never even mention inversions, and then get to a point where not only did you not do any inversion, you didn't even do it, like try to do it improperly. You just didn't do it at all. And of course, it can lead to erroneous test results. The other one about sodium fluoride, we talked about that. That is that anti-glycotic I mentioned. This book explains that it preserves glucose for up to 3 days. Transit in Ohio can take an extraordinary amount of time. It's not going to be refrigerated. As long as we are in the mail, we're fine. It just doesn't work with science so well. So now your Candida albicans are going to start working on that, working in your little vial and producing alcohol for you. So this book, you can get that in. And now you've made them aware at the motion suppress. When it comes to a trial, they are aware. We've got a slide on it. It's my favorite. Aren't you aware? And then anything I've already talked about.
Yeah, if you know that the courts have basically said it can be in the car in 90-degree weather for 5 days and everything's fine. So you're not going to win it at a motion to suppress. You just got to get somebody to acknowledge the information that you want a jury to hear at the motion to suppress so that you have it when it comes time to try the case.
All right, so we have a question from the people at home. It says, where are these materials? These should be in the Dropbox link. We're still syncing to the Dropbox link, and they will be there shortly if they're not already. All right, so this one, this is the new manual of the Intoxilizer 8000 here in Ohio. This has become an issue for me recently. This is from March of 2020. It's not exactly new, but it's newer than the series of manuals that they've gone through. So one of their earliest manuals had the troubleshooting guide. That's what they called it. So on the back, they went through all of the possible error messages. And if the error message appeared, you knew what to do about it. They would tell you, oh, well, run the test again. Wait, they never said wait 20 minutes, but run it again. And if you get the same error, take the machine out of service and call the ODH. That used to be true for RFI. So the guy in the next room's radio screws with the test. We get 2 RFIs in a row, and that's the machine should have been taken out of service. Now I get to go into the motion hearing or trial and say, you had successive errors on this thing. You didn't take the machine out of service and you should have. So they ditched that part of the manual. They replaced it later with a different version that basically never says you have to take the machine out of service. Do they say you should contact ODH in a couple of instances? Yes, they do, but they remove that for nearly every, I believe it is every single error. Nothing causes the machine to be taken out of service. Some of them say you have to contact the ODH, but nothing says to remove. So it got a lot better for them. But in their process of editing this manual, I would flip to the page, but the reason it's just a slide is this page doesn't exist anymore. It used to be that if you got an unstable signal, they'd say do it again. And if you got that test result twice in a row, remove that thing from service and call ODH. But in the 2020 manual, they forgot to put that in at all. So if you have this unknown error, you have no idea what to do with it because you have to have the manual right there in the room when you're conducting breath testing. You just got this error. You have no idea what it is. The manual doesn't have anything to do with it. You're just going to keep using that machine. And you're not going to use the event report. You're not even going to call ODH. You're not going to use a form that they give you right there in the manual. Hey, we had a problem. We're just going to keep on using the machine.
And we have a pending case right now with exactly those facts, but we haven't had the motion to suppress hearing yet.
I got a deal on 2. One of them was a really bad case, but we ended up with a good result. It just hasn't gone to hearing yet. I was just going to say something else. Oh, that's how you find these. So you just go to the website. You scroll through. You look at you don't have to search by the person's name. You search by serial number. You look at your client's serial number. You don't put in that. You hit the officer details and under officer details, it says serial number. You put in 80-00, then the 4 digits of your serial number. You can go through all the tests on that machine. So just keep backing down, keep clicking on names. Eventually you'll have to answer a CAPTCHA, but keep clicking until you find an unstable signal. And we're finding them all over the place. Because it is a true error that it produces naturally in its code, but they removed it from the manual. Question is, am I running into very many officers that have been trained after March of 2020? I don't even really address that because they have to have the manual in there where they're conducting the breath testing. So they can't have an out-of-date manual. I give them the current manual, and I mean, half these guys don't remember their training anyway. Right. They have to do their proficiency, which is just running a test once a year, but nobody's going back for training. So you can use some of those older manuals if it works out. If anybody's savvy enough and you're trying to introduce an old manual, you'll get shot down on that. But this is why you have to go to the breath machine. We all used to go to breath machines on the data master and investigate, oh, did they do their checks within 7 days, 8 days? But I just went to one for Ken on the 8000, and if you go and you find their manual, you know what they're operating on. You can say it's the same one. If you find an old one in the book and that's what they're relying on to how to operate the machine, then you can use that. But just to stress one other point, Ken sends me to look at breath machines. I've looked for other attorneys. I've looked for Pat. I go to the breath machine look because we had a case. I was the attorney of record for my client right after arraignment. I went over the post, looked through other stuff, and the top of the antenna had been broken off on the data master. I took pictures of it. We were bringing in Tom Workman to testify about RFI. I luckily had left, I was working for John Say at the time. I was no longer working for John, because when that prosecutor said, no, I won't stipulate to the pictures, Hada's going to have to come in and testify. I'm sitting around all day, but luckily I'm not the attorney of record anymore. If I make myself a witness in my own case, then I got a problem. So if I go and look for somebody else, I'll do the investigation. You're free to issue a subpoena to me if I need to testify about something or send over a picture, and you don't end up screwing up your own case.
And he can write a report.
Mm.
So the attorney of record who cannot testify has somebody who can. And they can find exactly the same thing, except that I can use his testimony as opposed to the fact if I go and find it, I can't use it.
All right, so those are some of the things. My book is here on the floor somewhere. Anybody's willing to grab it, look through it. There's fun stuff in there. It's not just this manual, the other manual, the white data master that says invalid sample, i.e. mouth alcohol. Others aren't as clear on that subject, so you want to get if you want the right manual, it's in the book. Everybody should carry around one of these books. All right, so we're going to try and talk about getting from motion to suppress to trial. I guess I animated that one. All right, so if we do this, sometimes we send them the materials prior to the motion to suppress. Hey, we're going to talk about this study. One of our officers, who was a guy in Stowe, super prepared.
Yeah.
He showed up with Ken's whole profile from his website, just printed out in a file. He was researching Ken before the hearing started. So some officers are a little bit more in tune with these things, and if you give it to them, they're going to read it. But that's very much in the minority. Most of these people are going to get it. They have no idea where you're going with it, and then you can go the extra mile and say, "I even gave it to you, and you didn't read it," just like Brock was doing with Josh. So give it to them in advance. Give it to them in advance of the trial, and then you've got that magical question. You are aware. Well, of course we know they're aware. We made them aware. We talked to them about it at the motion to suppress. We've got that transcript there for them. I know there's something else I want to talk about with the manuals and
French.
yes, we'll talk about French. Oh, the links. We'll get to the links later. All right. So state versus French. Blaze and I had a discussion about this. Sarah and I talked today. I know what Tim's opinion is, but John agrees with you. How do you take French?
I had a trial where I purposely did not challenge the fields because they were done so poorly. He started testifying about field sobriety tests. He said everything. I started to cross-examine. And I started to talk about all the things he did wrong.
Was this at the trial or?
At the trial.
Okay.
The judge says you can't do that. You didn't file a motion to suppress. And I said, I am not arguing the fact that they are admitted into evidence. The jury can hear everything he said. I didn't object one time. But they also can determine whether they want to believe that or whether they want to totally discount it. So I am challenging the weight that the jury should give to those tests, not whether the jury should hear the results. And the judge says, you can't do that. And I use state versus French, which is an Ohio Supreme Court decision. It was dealing with a breath test, but it's whether you have to lay a foundation. But it was a 9-0 decision, 7-0 decision. It was unanimous. And I finally got the judge to allow me to cross-examine the officer on the field sobriety test. And that's where we want to use them.
French was talking about the breath test. When I remember when we were preparing this underneath state versus French, I had John's case because I couldn't remember the name of it because he used it in that case where I was a witness, and it was NAPKey. Did I tell you that before I removed it? It was NAPKey. That one applies to Dynamis, yes, breath machines, thank you, not field sobriety tests. All right, so you are aware, I think gets us there all, every time all day. But if you can stack that on top of other rules of evidence to help shoehorn these things into trial and hit the judge with as many good reasons to get this in the trial as you can, then great. Got two of you. Yes. And I was just going to say that. Tim just brought up the fact that Cincinnati versus Oregon addressed this issue as well, argued by the late Steve Adams. Normal, regular guy at these seminars, we miss him a lot. So, Brock. Thank you.
What is the argument, if it can be stated cleanly, that French says that if you don't file a motion to suppress fields, that you cannot attack their weight at trial? Or is that an argument at all?
No, because what they're saying is that if you don't challenge it, they don't need to lay a foundation. They can just admit it.
The argument is that Vega, basically Vega applies to SFSTs just like they applies to breath. So the argument is under Vega, if you don't file a motion to suppress, then you lose the right to challenge it at trial. And then French obviously followed up on Vega. So it's basically a Vega argument.
Well, as long as you make the distinction between admissibility and weight, you're fine. Because the whole argument is the jury can hear all of it. I'm not challenging that. But I want them to look at that and say, that's bullshit. You got to do it the right way. Didn't do it the right way. We have no reason to believe that.
And there's actually a great case out of the 10th district that basically obviously screwed the defendant, because that's how those cases happen, right? But they claimed that the defendant failed to file a motion in limine on the field sobriety test after he lost in the motion to suppress, and he didn't re-raise it. So therefore he couldn't challenge it at, admissibility at trial because he didn't do it as a motion in limine. So they make it clear that the SFST motion to suppress is not the end all and be all for trial evidence. That's Droughton, D-R-A-U-G-H-T-O-N.
Mr. Gardner.
The 8th district has a case where Boza prevented the defendant because he didn't challenge it in a motion to suppress. He barred him from challenging the
Wasn't your case with Boza?
field sobriety test. They went to the 8th and they said, yeah, of course you're allowed to challenge it, but evidence is so overwhelming of its application, it's harmless error.
Well, that case was after my case because it was with Judge Boza where she let me cross-examine the officer.
All right, so
But evidently,
Before your case,
no, she would have known because she gave me a huge argument about I didn't file a motion to suppress. So it was before that, and evidently in the case you're talking about, the defense lawyer never raised French.
There's also another case, a really great case for most things except for this issue, and I think it's Brock's case and Larry Denny's, State versus Sixth. Is that your case? State versus Sixth, where they would not let you cross-examine on field sobriety tests at trial. Say Adams, isn't it? There's also State versus Sixth, where it was a Larry Denny case where basically the court was great on every other issue, but at trial on trying to basically challenge the officer or even ask him about how he did it. Now, this wasn't on a waiver of the motion to suppress. This is when they did the motion to suppress, wouldn't let him ask about it at trial because the judge basically said, I found it's admissible.
Yeah.
So
yeah, I think you're going to find case law on this around Ohio. Soon, Mark was mentioning a case out of the 8th. He didn't have him on a microphone, but they found harmless error in that one. But I mean, we've got judges, one in Cleveland that says that the substantial compliance of the field sobriety test is not an issue in a motion to suppress hearing. Yeah, I saw that. Look. Anybody in Cleveland? We don't get to say it out loud.
In fairness, that was 2 months after Holman came out.
No, it wasn't.
Chase?
No, right. So this is like last year. All right, so besides those issues, there's a few other ways we can use the shoehorn this in. What are we looking at on time? When are we supposed to be over?
5, quarter to 5.
17 minutes left. I think we started a bit early too. 17 minutes to fill. Looks like we're all getting another break. All right. This one I already talked about. I talked about using that phlebotomy book. This is great. I've laid the proper foundation and gotten denied before, but you just get them to say that this is an authority that they would rely on. That this person on saying would rely on it for reference, and you can cross based on the contents of that resource. Official publications. These are self-authenticated. These are where you don't need extrinsic evidence. Books, pamphlets, other things issued by a public authority, say NHTSA. So in preparation for this presentation, an official publication might be where the government actually, what's the website that they use? It's some library website to officially publish these. So there you can see if they're saying, hey, is this a legit copy of it? These are the links you go to. These are the true publication links for each one of these studies. What we wanted to do was provide all of you with certified copies. I know Sean went through this. Also in my book is the certified copy of NHTSA's policy on traceability that Sean got certified by NHTSA, which is just a printout of their website, certified. But we want to give you all certified copies of these studies, but they're not going to come in time. And the reason for that is because it requires a FOIA request, and they're just not here yet.
But if you want to do it, we supplied the link.
I probably will, but not for today. Sorry, got a little bit of a late start on this one. So, but I want to get certified copies in case it ever became an issue, even though they are self-authenticated. Another one is judicial notice. It's judicial notice for facts not in dispute, generally known in the jurisdiction, or readily determined from accurate sources. And an accurate source would be that governmental publication of those studies. So that's one other way we can use public records and reports, 8038. These are activities of the agency, whether that be NHTSA or some of these other ones. Did I miss?
No.
I thought I missed one. Okay, commercial publication. The BD Vacutainer tube chart, that's a commercial publication they put in every hospital. If you go back to get your blood drawn, it's probably right there on the wall. But that is a commercial publication. Not just that one, but the weight chart was a commercial publication by that life insurance company. This can you can find a number of weight charts issued by a number of even governmental organizations. The newer ones, like I said, will operate on BMI. But what they do is they take this approximation and they still give you a weight chart. Yeah, you should get your body fat percentage taken, but here's the weight you should be. So if you can find a good one, go ahead and roll with it, and you'll have everybody over 50 pounds overweight. All right, so I think that was the last way we had that we were shoehorning these in. But all of those things we talked about, there are ways to get it in. If nothing more than you are aware, that's great. But if you can pile one of these on top, even better. And most of them have at least one of these that you can pile on top for getting that admitted.
Yeah, the most important thing is I don't believe anything is inadmissible. As long as you can get somebody on the prosecution side to acknowledge it ahead of time, because then you have the ability to cross-examine. So is it admissible? Always.
And it's whether it's these or the studies that Sean was talking about with marijuana, or the one that says people actually drive better on low levels of marijuana. Or how Adderall, makes you drive better. So there are some great studies out there. If you guys have anything, come up with anything, let me know. We'll add it to the book, and I'll give you a table of contents for my book, and we'll build that up. So thank you, guys.
Thank you.